All right, let's dive into California eviction law. It can get pretty complicated, so we're going to break it down and figure out what you really need to know as a tenant.
Yeah, California's always trying to find that balance, you know? Protecting both tenants and landlords. That's what makes it so nuanced, especially with all the recent updates.
So our listener wants to know about their rights if they're renting. And we've been digging through a ton of legal guides and FAQs, even some real-life case examples. Honestly, some of this stuff is wild. Like, did you know some landlords are still trying to pull those illegal self-help evictions? Even in 2023.
Oh, it's true. And the penalties, they can be huge EE. We're talking like changing the locks.
Wow.
Shutting off utilities, just totally wrong.
Yeah, that definitely screams wrong.
That's why it's so important to understand the whole just cause principle in California, especially since they passed the Tenant Protection Act back in 2019.
Just cause. That sounds pretty serious. So I'm guessing this is like the foundation of everything else.
Absolutely. It basically means a landlord can't just decide to kick you out on a whim, especially if you've been living there for over a year. They need a valid legal reason, a just cause. And these reasons usually fall into two categories: at-fault evictions and no-fault evictions.
Okay, so at fault, I'm guessing that means the tenant did something wrong.
Right. Think of it like not paying rent, violating the lease, or maybe even doing something illegal on the property. Those are the big ones.
And then no-fault evictions. That sounds kind of counterintuitive. How can you get evicted if you didn't do anything wrong?
Well, it's not always about what the tenant did. Sometimes the landlord has a reason to want the property back. That's totally unrelated to the tenant.
Okay, I need an example.
Sure. Let's say the landlord decides they want to move into the unit themselves, or maybe a close family member needs a place to live, or they've got plans for a major renovation, something that would make it impossible for the tenant to stay there. Those are some common no-fault situations.
So even if I'm the perfect tenant, paying on time and following all the rules, I could still be asked to leave. That seems kind of unfair.
It can feel that way. But California does try to protect tenants in those no-fault situations. For example, sometimes the landlord has to provide relocation assistance, like money to help with moving expenses.
Okay, that makes a little more sense. It's still disruptive to have to move. But at least they recognize it's an inconvenience. So let's say my landlord just wants to repaint and raise the rent. That doesn't fly as a reason for a no-fault eviction, right?
Not at all. They need a more substantial, legally valid reason. Just doing some cosmetic updates or trying to raise the rent, that doesn't usually qualify.
Got it. So landlords need a valid reason to evict someone, especially in California. But how does this just cause thing actually work in real life? What are some common scenarios for these at-fault evictions?
Well, as you might expect, not paying rent is a major one. If a tenant keeps missing those rent payments, that's a pretty clear-cut case for eviction.
Right, rent is like the whole foundation of the agreement.
Exactly. And in those cases, the landlord usually starts the eviction process with what's called a 3-day notice to pay or quit.
Okay, so that's the official warning: pay up or move out.
Exactly. It gives the tenant a very clear time frame. Either fix the situation or leave the property.
And if they just ignore that notice and don't pay within those 3 days, things can escalate pretty quickly, right?
Absolutely. It can lead to a lawsuit and formal eviction proceedings. But it's not always about missing rent. Sometimes it's about violating the terms of the lease agreement.
Okay, so things like having unauthorized pets, or throwing those wild parties that disturb the neighbors, or damaging the property.
Exactly. Those are all common lease violations that can lead to an eviction. And in those situations, the landlord might start with a 3-day notice to cure or quit.
So it's similar to that pay or quit notice. But instead of demanding rent, they're giving the tenant 3 days to fix the problem.
Precisely. It's basically saying, hey, you're violating the lease. You've got 3 days to fix it or move out.
And if they can't or won't fix the problem within those 3 days, what happens then? Does the landlord just call the movers?
Not quite. There's a very specific legal process they have to follow. If the tenant doesn't fix the situation or move out after that 3-day notice to cure or quit, the landlord might escalate to what's called an unconditional 3-day notice to quit.
Unconditional. That sounds serious.
It is. This type of notice basically terminates the lease agreement and demands that the tenant leave the property within 3 days, period. No more chances to pay or fix anything.
Whoa, so at that point it's game over.
Not necessarily. Remember, in California, the tenant still has rights even when facing eviction. But it's super important to understand that ignoring these notices can have really serious consequences.
Okay, so don't panic. But don't ignore the situation either.
Got it. So let's say a tenant gets that dreaded unconditional 3-day notice to quit, and they don't leave. What happens next? Is it like a Wild West showdown with the landlord kicking down the door? Definitely not. Evictions have to follow a very specific legal process in California. The landlord can't just take matters into their own hands.
All right, good to know. So what does that legal process look like? Walk us through it step by step.
Okay, so once those initial notices have been served and the deadlines have passed, if the tenant hasn't complied, the landlord can file what's called an unlawful detainer lawsuit.
Unlawful detainer? That sounds intense.
It is. It's the formal legal process for evicting a tenant in California. The landlord files this lawsuit with the Superior Court in the county where the property is located.
So we're talking actual court proceedings, judges, lawyers, the whole 9 yards.
Exactly. And this is where things can get more complex and honestly pretty intimidating for tenants who aren't familiar with the legal system.
Okay, let's break it down for us. What happens after the lawsuit is filed?
Well, first, the tenant has to be officially served with the court documents, which include a summons and a complaint. These documents outline the reasons for the eviction and what the landlord is demanding.
So it's like getting a legal summons to a party you really don't want to attend. So if I'm a tenant in this situation, what should I do? Just hide under the bed and hope it all goes away?
Definitely not. Ignoring those legal documents is the worst thing you can do. You have a limited amount of time to respond, and if you don't, it could lead to a default judgment against you, which means the landlord automatically wins the case.
Yikes. That sounds like a recipe for disaster. So what are my options if I'm the tenant?
You have a few choices. You can file an answer with the court, which basically means you're disagreeing with the landlord's claims, and you're going to present your own defense.
So I could argue that the eviction notice was improper, or that the landlord is retaliating against me for something.
Yeah.
Or maybe even that the property was uninhabitable.
Exactly. Those are all valid defenses that we'll explore in more detail later. Or you could file a motion to quash, which challenges the way you were served with the lawsuit. But the key is to take action. Don't just sit on it.
Okay, so don't panic, but don't ignore the situation either. Got it. Let's say the case actually goes to a hearing or a trial. What can a tenant expect at that point? Is it like what we see on TV, courtroom dramas?
Well, it's not quite as dramatic as Hollywood portrays it, but it is a serious legal proceeding. Both the tenant and the landlord will have the opportunity to present their sides of the story, offer evidence, and even call witnesses if necessary. The judge will then evaluate all the information and make a ruling.
And if the landlord wins,
Right.
what happens then? Does the tenant have to pack their bags and leave immediately?
Not necessarily immediately, but it does mean the eviction process is moving forward. If the landlord wins, the court issues what's called a judgment of possession, which basically confirms the landlord's right to take back the property.
So that's when the sheriff or marshal comes knocking, right?
Right. If the tenant still refuses to leave after a judgment of possession, the landlord can request a writ of possession, which authorizes law enforcement to physically remove the tenant from the property.
This whole process sounds pretty stressful and expensive.
It absolutely can be. Evictions are costly for everyone involved. Court fees, legal fees, lost rent, it all adds up. That's why it's often in everyone's best interest to try to resolve things amicably if possible.
That makes sense. But let's be realistic. Things don't always go smoothly. So we've talked about these general principles of just cause and the legal process of eviction. But you mentioned earlier that California eviction law is constantly evolving. What are some recent changes that tenants need to be aware of?
Well, California lawmakers are always tweaking and refining these laws. They're always trying to find that balance between protecting tenants and recognizing the rights of landlords. One recent change is Assembly Bill 2347, which actually gives tenants a little more time to respond to that unlawful detainer lawsuit, 10 business days instead of 5.
Okay, so a little bit of breathing room there.
Another significant update is Senate Bill 567, which puts stricter rules around those no-fault evictions we discussed earlier. Landlords now need to provide more documentation to justify those evictions, and in many cases, they're required to offer more substantial relocation assistance.
So greater protections for tenants facing those no-fault situations. That seems like a step in the right direction.
It is, but it's important to remember that California eviction law can be like a layer cake. You've got the state laws, but then many cities and counties have their own local ordinances on top of that provide even greater tenant protections.
It sounds like a lot to keep track of.
It absolutely can be, and that's why it's so important to be informed and to know where to turn for help if you're facing a potential eviction.
All right. Deep divers. That was a lot of information. but we've only just scratched the surface.
You've got a lot more to cover.
We'll be back to explore even more about your rights as a tenant in California. Don't miss it. Welcome back, Deep Divers. We're picking up right where we left off, talking all about California eviction law. And this time we're getting into the nitty-gritty, what you can actually do to protect yourself as a tenant.
Exactly. We've laid the groundwork, talked about just cause, those notices, the whole unlawful detainer lawsuit process. Now let's give you some practical knowledge, some tools you can use.
Last time we touched on how complex this can all be, especially with all those different layers of law, state laws, county laws, even city ordinances. It's like a legal maze out there. But one thing that kept coming up in our research was the importance of documentation.
Oh, absolutely. Documentation is crucial. For both landlords and tenants, it can literally make or break a case. We've seen so many situations where having the right documentation could have completely changed the outcome.
Okay, I'm intrigued. Sounds like we're about to unlock a secret weapon here. Break it down for us. Why is documentation so important? And what kind of documents are we talking about?
For landlords, it's all about protecting themselves legally. Thorough documentation helps them show that they've followed all the rules, that they've communicated with the tenant properly, and that they have a valid reason for taking action.
So we're talking about things like the lease agreement, any notices they've served, proof that those notices were delivered correctly, records of rent payments, all that needs to be carefully documented.
Exactly. And don't underestimate the power of communication logs every time a landlord talks to a tenant, whether it's through email, text messages, even phone calls. It's a good idea to document it. Just a quick note with the date and time and the main points they discussed can really make a difference.
Yeah, I can see how that would be helpful. If there's ever a dispute about what was said or agreed upon, it's like having a paper trail to back up your claim.
Precisely. Imagine a situation where a tenant claims they never got a notice, but the landlord has a signed and dated proof of service. Or maybe a tenant says they've always paid rent on time, but the landlord has a detailed record showing missed payments. Documentation can quickly settle those arguments.
So for landlords, it's about covering their bases, being organized,
Yeah.
and having that paper trail, just in case things go wrong. But what about tenants? How does documentation help them protect their rights?
Well, for tenants, documentation can be just as powerful, especially if they're dealing with a difficult landlord or a situation where their rights are being violated.
Okay, I'm following you. So if I'm a tenant, what kind of things should I be documenting?
Any issues with the property, that's a big one. Let's say there's a leaky roof, a broken heater, a pest problem that just won't go away. Document it, take photos, videos, write down the dates and times, keep a record of any repair requests you've made, and how the landlord responded.
It's like building a case file, gathering evidence in case you need to take action.
Exactly. And don't forget to document any communication with the landlord. That seems off.
Wait.
Like anything harassing, threatening,
Yeah.
or retaliatory, if you're experiencing those kinds of issues. Having a record of those interactions can be really important.
So it's not just about problems with the property itself, but also any communication that feels wrong or inappropriate.
Right. Imagine a tenant facing eviction. The landlord says they damaged the property, but the tenant has timestamped photos showing the damage was already there before they even moved in. Or a tenant being evicted for complaining about a safety hazard, but they have emails showing they tried over and over to get the landlord to fix it.
Wow, those are great examples. I'm starting to see how documentation can really give tenants more power in these situations.
It absolutely can. It helps make sure everyone is being honest and taking responsibility for their actions. It can also prevent misunderstandings and disputes from turning into big legal battles.
Okay, documentation. Check. That's officially at the top of my list as a tenant. But what are some other things tenants should know about protecting their rights, especially during an eviction process?
One of the most important things to remember is that you have the right to stay in the property until a court orders you to leave.
So even if I get an eviction notice, I don't have to pack my bags and run.
Exactly. Don't let a landlord try to bully you into leaving early. The eviction process has to play out legally. You have the right to challenge the eviction, present your defense in court, and make sure your rights are being respected.
Like we said before, knowledge is power. The more you understand your rights, the better you can stand up for yourself.
Precisely. And if you're feeling overwhelmed or unsure about what to do, don't be afraid to get legal advice. There are organizations out there, often called legal aid societies, that provide free or low-cost legal help to tenants, especially those facing eviction. They can help you understand your options, explain the process, and even represent you in court
Okay, so legal help is available if you need it. That's good to know. Now let's dive into some of those common defenses tenants can use to fight an eviction. I'm particularly interested in this idea of retaliatory eviction.
That's a big one. And it comes up more often than you might think. Basically, retaliatory eviction is when a landlord tries to evict a tenant because the tenant stood up for their rights.
So let's say I complain about a leaky faucet or a break-in appliance, and suddenly my landlord slaps me with an eviction notice. That sounds pretty suspicious, right?
It could be. California law specifically says landlords can't retaliate against tenants for things like requesting repairs, reporting code violations, or even organizing with other tenants.
So how do you actually prove retaliatory eviction? Is it just my word against the landlord's?
Well, that's where documentation comes in handy again. If you've kept records of your complaints, repair requests, or any communication with the landlord, that shows a pattern of retaliation. That can be really strong evidence.
Okay, I'm sensing a theme here. Document, document, document. It's like a shield against bad landlords.
Exactly. Another strong defense is what's called breach of warranty of habitability. This one gets to the heart of the landlord's responsibility to provide a safe and livable place to live.
Okay, break that down for us. What exactly is a breach of warranty of habitability?
California law requires landlords to keep their rental properties in a habitable condition. That means things like working plumbing, heating, electrical systems, making sure it's weatherproof and free from pests and safety hazards. If those basic standards aren't met, it's considered a breach of that warranty.
So if I've got a mold problem that the landlord won't fix, or a broken window that's letting rain in, those could be breaches of habitability.
Absolutely. And if those problems are serious enough, like they're affecting your health and safety, you can use that as a defense against eviction, even if you're behind on rent.
Wow. So even if I'm in the wrong for not paying rent, if the living conditions are really bad, I might still have a case.
You might. Of course, every case is different, and the details really matter. That's why it's always best to talk to a legal expert. If you're facing eviction, they can help you figure out your situation and decide the best way to handle it.
Solid advice. Now let's talk more about those no-fault evictions. We mentioned them in the first part, but I think they deserve a closer look.
I agree. As we discussed, no-fault evictions happen when the landlord wants the property back for reasons that have nothing to do with the tenant's behavior.
Right. Things like the landlord wanting to move in themselves, a family member needing the unit, or maybe planning some major renovations. But even in these cases, there are rules in place to protect tenants, right?
Absolutely. And those rules have become even stricter in recent years, thanks to updates like Senate Bill 567 that we talked about earlier.
So what are the key things tenants should know about no-fault evictions? What are their rights in these situations?
First of all, the landlord has to give proper written notice, depending on the situation, and how long you've been living there. It could be a 30-day or 60-day notice to vacate.
And that notice has to clearly state the reason for the eviction, right? It can't be vague or misleading.
Exactly. The landlord needs to be upfront about why they're asking you to leave. And it has to be a legitimate legal reason. Remember, minor cosmetic updates or just wanting to raise the rent, those usually don't cut it.
And what about relocation assistance? Is that something tenants automatically get in all no-fault eviction cases?
It depends on the situation and the local laws in your area. But in many cases, yes. For example, under those new state laws we've been discussing, if a landlord is evicting you so they or a family member can move in, they usually have to provide some kind of relocation assistance.
Okay, so that might be financial help to cover moving costs, or even help finding a new place.
Exactly. It's meant to help with the cost and disruption of having to move. And it's important to remember that those relocation assistance rules can be different from city to city. So it's always a good idea to check your local ordinances or talk to a legal aid organization to understand your rights in your specific area.
So much to keep track of. But it's good to know that these protections exist for tenants. It's not a free-for-all for landlords.
Absolutely. California law recognizes that even no-fault evictions can be tough on tenants, and it tries to make sure things are fair and that tenants have some support.
Well said. We've covered a lot of ground in this part, from the power of documentation to those crucial defenses against eviction. I feel like we've given our listeners some real tools to work with.
Definitely.
But we're not done yet. We got more to explore in part 3, where we'll dig into some real-world examples. To bring all this information to life, stay tuned, deep divers. All right, welcome back, deep divers. We're in the home stretch of our deep dive into California eviction law. After all this, I'm starting to feel like I could argue a case myself.
Well, that's the goal. We want to give you the knowledge and confidence to navigate this stuff, whether you're a tenant or a landlord.
Exactly. We've covered the principles, the processes, the defenses. Now it's time to bring it all to life with some real-world examples.
Love it. That's always the best way to really understand how these legal concepts actually play out, right?
Totally. Plus, I'm sure our listeners are eager to see how all this applies to their own situations. Make it real.
Absolutely. So let's start with a scenario that, unfortunately, is pretty common. A tenant who's fallen behind on rent.
Okay, I'm picturing it. Our hypothetical tenant, let's call him Alex, recently lost his job.
Happens all the time, unfortunately.
Right, and he's having trouble making ends meet. He misses a rent payment, and his landlord, we'll call her Mrs. Landlord, doesn't waste any time, slaps him with a 3-day notice to pay or quit. So what are Alex's options here?
This is where knowing your rights is so important. A lot of tenants see that notice and freak out. They think they have to be out in 3 days no matter what. But remember, that's not how it works in California.
Right, we talked about how those notices are just the first step in a much longer legal process.
Exactly. So Alex has some time to figure things out.
Okay, so what's his first move?
Ideally, he'd come up with the rent money within those 3 days. Maybe he can borrow from family, dip into savings, or find some kind of emergency assistance.
Makes sense. But what if he just can't pull that much cash together that quickly? Is it all over for Alex?
Not at all. Remember, communication is key. Alex should reach out to Miss Landlord, explain his situation. If he can show her he's actively looking for a new job, that he's committed to catching up on the rent, she might be willing to work with him.
So it's always worth a shot to try and negotiate a payment plan, right?
Absolutely. You'd be surprised how many landlords are actually pretty understanding. They'd rather work with a tenant than go through a whole eviction process. It's a hassle for everyone, and it can get expensive.
That's a good reminder that it doesn't have to be a battle all the time. A little empathy and open communication can make a big difference.
For sure. But let's say Alex tries to negotiate, and Mrs. Landlord is just not having it. She's sticking to her guns. What happens then?
Well, I remember you saying that Alex still has the right to stay put until a court orders him to leave. Mrs. Landlord can't just change the locks and kick him out, right?
Right. If she wants to evict him, she has to follow that formal process, the whole unlawful detainer lawsuit thing we talked about, filing paperwork, having Alex served with court documents and all that.
And I'm guessing it could even go to a hearing or a trial?
Exactly. But even then, Alex has a chance to present his side, explain his situation, and maybe even work out some kind of settlement with Mrs. Landlord. Like maybe they agree on a move-out date and she drops the lawsuit. There's often room for negotiation even when a tenant is behind on rent.
Gotcha. So that's how things might go down in a rent-related eviction. But what about a situation where a tenant violates the lease?
All right, let's say our tenant this time is Samantha. She loves to garden and has turned her balcony into this gorgeous little oasis.
Sounds lovely.
It is, but there's a problem. Her lease says no plants on balconies.
Oh, sounds like we've got a lease violation brewing.
Right. So Miss Landlord, sticking to the rules, as always, sees those beautiful plants and boom, hits Samantha with a 3-day notice to cure or quit.
So Samantha's got 3 days to get rid of her beloved garden or face eviction. Tough choice. What if she argues that her plants aren't hurting anyone, that they actually make the building look nicer? What are her chances?
That's a tricky one. It really depends on how the lease is worded, what kind of evidence she has, and honestly, the judge. Leases are legally binding contracts, and tenants usually have to stick to what they agreed to.
So in this case, Samantha might be better off just taking down her garden and maybe trying to talk to Ms. Landlord about changing the lease later on.
That's probably the smartest move. Sometimes you gotta pick your battles, focus on the bigger issues.
Agreed. Okay, let's try one more example. A no-fault eviction this time.
Sounds good. Let's say our tenant is David. He's been living in the same rent-controlled apartment for over a decade. He's the perfect tenant. Always pays on time, keeps his place clean, never causes any trouble. But then one day, he gets a 60-day notice to vacate. The reason? Miss Landlord's mother is moving to town and needs a place to live.
Oh, man, that's rough. David's done nothing wrong, but he's being forced to move. Does he have any recourse? What are his rights?
Well, remember, even in no-fault evictions, California law still protects tenants. First off, Mrs. Landlord has to have a real reason for wanting the property back, and she has to follow all the right steps for serving that notice.
So it's not enough to just say, my mom needs a place to stay.
Nope. She needs to prove it. She'll probably have to show some documentation, like a lease agreement or proof of residency, to show that her mom really intends to live there.
And what about relocation assistance? Does David have a right to some financial help with moving expenses?
Most likely, yes. In cases where a landlord is taking back a property for personal or family use, California law usually requires them to provide some sort of relocation assistance.
Okay, so even though David is being evicted without doing anything wrong, he's still got some protections and some help.
Exactly. The law recognizes that no-fault evictions can still be disruptive and expensive. It tries to make the process a little less painful for tenants.
It's good to hear. These examples have been so helpful. It's crazy how many little details and nuances there are in these laws.
I know, right? And remember, these are just a few examples. Eviction cases can get really complicated, and every situation is different.
So true. Well, folks, it looks like we've reached the end of our eviction law adventure. What are some key takeaways you want to leave our listeners with?
I think the biggest one is that whether you're a landlord or a tenant, it's so important to know your rights and responsibilities. Don't wait until you're in a crisis to start learning.
Yeah, knowledge is power, especially when it comes to evictions.
Absolutely. Learn the laws, stay updated, and don't be afraid to ask for legal advice if you need it. There are resources out there to help you.
Couldn't have said it better myself.
Hi.
All right, deep divers, that wraps up our exploration of California eviction law. We hope you found it informative and empowering. Remember, stay curious, stay informed, and keep diving deep into the world around you.
Call now 71444429741. Thank you.